Hello and good day. Today we are discussing a problem of the vehicle finance industry. Vehicle finance industry includes the banks and the non-banking finance companies which lend against security of vehicles. Vehicles once again could include two-wheelers or four-wheelers or trucks or commercial vehicles or tractors, even something like construction equipment if they come under the definition of motor vehicles under the Motor Vehicles Act. And the reason why we're discussing this topic today, the topic incidentally is multiple registration of security interests and the impact of non-registration. Multiple registrations of security interest. Security interest basically is what the hypothecation or the lien on the vehicle that you hold, and registration is the perfection of the security interest by registering the security interests with one or more registries. And the issue basically is that there are multiple registrations for such security interests in Indian context. And the trigger for this short video presentation is the recent, not very recent exactly, because this is actually about a couple of months old, ruling of National Company Law Appellate Tribunal, holding that if the security interest on the vehicle is not registered under the Companies Act, mind you, then the charge remains imperfected, charge remains void as far as the liquidator or the lender, the secured creditor, is concerned. And this is of course not a new law. This is not something which is taken by, at least my view has consistently been this, and therefore I'm not taken by surprise at all. But what one of these rulings brings to focus once in a while is that there might be issues which people do not realize, and these rulings help us to kind of refresh ourselves with a fundamental lapse. I'm using the word lapse because I'm aware that in most cases of vehicle financing, financiers are contented with the registration certificate of the motor vehicle bearing the name, and they do not take the trouble of ensuring that the borrower, if the borrower happens to be a corporate, if the borrower happens to be a company, they do not take the trouble of ensuring that the company has filed a charge under the Companies Act. So that's exactly the issue of multiple registrations. And there are as many as 3 registrations under different institutes, and we're going to discuss the impact of these. But the central point before us is the fact that in most cases, registration under the Companies Act is missing. And what impact does it have is something that we got to we get to relate it with the recent ruling of the NCLAT in case of a company called Volkswagen. Which companies involved doesn't matter. The issue basically is that this is a practice which is uniformly prevalent in the financial world, be it banks or be it non-banking finance companies. While vehicle financing is mostly done to individuals, but there are plenty of cases where the borrower happens to be a company, a body corporate, a company, or an LLP. And in those cases, if the financier does not ensure or does not, I mean, as a matter of post disbursement check, does not ensure that the vehicle, the security interest is registered with registrar of companies as well, the consequence would be that the charge remains, the loan remains unsecured. Unsecured loan will have its own implications. Implications under what law? Implications under Insolvency Bankruptcy Code, or implications under the common law, or implications under the SARFAESI Act when it comes to repossession right. That is by itself a complicated question on which we'll spend some time discussing that. It's not a compliance issue. Therefore, let's not think that there's a major lapse in compliances. It's not a compliance issue. It's, however, something that you need to ensure that your security interest is perfected. Otherwise, you will be ranking, at least in insolvency perspective, at par with an unsecured lender, which is what is the ruling coming in the present case. So I'll quickly take you through this issue. And like I mentioned, I'm aware that in most cases, most financiers, be it bankers for sure not, or most likely not. Similarly, NBFCs, to the extent I am aware, NBFCs also do not take the trouble of ensuring the security interest is registered with the registrar of companies. Let me first bring in the whole issue of multiple security interests. And like I mentioned, the relevance of the topic, it's not a compliance issue. It's something which is having to do with the perfection of security interest. And the issue arises from the ruling of the NCLAT, like I just mentioned, in a case called Volkswagen. That's the name of the case, and that's the citation of the case. The matter pertains to non-registration of a charge under Section 77 of Companies Act. And therefore, the issue pertains to all those cases where the financing is done in respect of a motor vehicle. Motor vehicle should, of course, be read in context of the Motor Vehicles Act. And the Motor Vehicles Act has multiple types of motor vehicles registered under that act, but that includes two-wheelers or includes motor cars, heavy goods vehicles, tractors, road rollers, and so on, heavy passenger vehicles, light motor vehicles, and so on, even certain construction equipment. Wheel-mounted construction equipment may also be falling under the definition of Motor Vehicles Act. Now, why is this issue at all coming? Because, as I mentioned earlier, that in case of financing of motor vehicles, the Motor Vehicles Act provides for endorsement of the hypothecation of the vehicle on the registration certificate. The registration certificate, of course, mentions the name of the borrower as the owner, but it contains an endorsement the vehicle is hypothecated to XYZ financier. And that is mostly taken as all that I need by most of the financiers. That's my name is there on the RC. So why would I bother if the borrower does not register the charge with registrar of companies? But if the borrower or the co-borrower happens to be company, that's second condition when we need to bother about this issue. The funding is for a motor vehicle. The borrower is the borrower or the co-borrower. I'm using the word co-borrower, but I am aware that in many cases, the borrower might be an individual, but we take the company as a co-borrower. So if the borrower or the co-borrower is a company and the transaction is one of a loan, it's not a lease or hire purchase transaction, which is where the question of registration of security interests would come. In such cases, we need to stand up and take notice of this particular ruling. So this is what I'm going to do in next 10 to 15 minutes to discuss the relevance of multiple registrations. It's a complicated issue. The issue of multiple registrations itself is a complicated issue. I'm not saying it's desirable to have multiple registrations. Unfortunately, we still have a fragmented registry systems in India, while the World Bank, other policymakers have always been advocating unification, synthesization of security registration systems for what is called movable properties. Unfortunately, that's still not happened. SARFAESI, the Central Registry under Securitization Act, was conceived as an integrated or single point registry. Unfortunately, however, that's far from real as of now, and therefore the Companies Act still requires its own registrations. The motor vehicle still has its own registration systems. In case of certain other properties, for example, let's say land, immovable properties, there might be state level registry requirements as well. So registrations under different statutes, say in case of trademarks, there'll be registration under trademarks law, under copyrights as well, and patents as well. So multiple registrations of specific assets still remains an issue, and that issue can actually result into extremely undesirable consequences. So this is what we're going to discuss. We said basically in context of motor vehicles, which is my topic today, we can at least think of 3 registrations. I'm saying at least because I'm not even sure that there might even be some other, well, I cannot broadly think of other registrations, but yes, there are primarily 3 registrations under 3 separate statutes. Number 1, the SARFAESI Act. I did mention the SARFAESI Act was actually envisaged, and this was the thinking when the SARFAESI Act was envisaged way back 2002. There was a prior thinking of having something similar to Article 9 of UCC. So centralization of registry systems was the grand design of the SARFAESI Act. It's lost its relevance somewhere. There is a provision in the SARFAESI Act talking about integrated registry. There have been several moves to amend the SARFAESI Act time and again. The registration system has been amended several times to make it from a compulsive system to a motivative system. However, The idea of an integrated registry is still a far cry. So there is a registration under SARFAESI Act. There is, of course, a very common registration under motor vehicles. That is a purely operational requirement, because the motor vehicles does have a registration certificate of the motor vehicle. And in case the vehicle is taken or financed by a loan or hire purchase or a lease, then there is a registration or endorsement on the registration certificate in favor of the financier. And then in case of corporate borrowers, companies, if the company happens to be a borrower, there's a question of registration of charges under the Companies Act. I'm sure everyone understands that Companies Act has always had a system of registration of security interest or charges on any of the properties of the company. That property could include a motor vehicle. In case of motor vehicles, the problem becomes a little more acute. And I'll just say why in next couple of minutes. So there are three registrations at least. The registration authorities in each of these cases also are different, very obviously. In case of SARFAESI Act, the registration authority is the SARSAI, Central Registry under Securitization Act, SARSAI. That's as the name implies, a central registry. So that's only one SARSAI in the country. In respect of motor vehicles, every state has its own registration facilities for motor vehicles. And of course, registrar of companies also is sort of centralized, though there are several registrars. Every state has its own registrar, but the system is completely now interlinked, and therefore one can envisage the registration under the Companies Act also as a centralized system. Who is applicable in what case? Under SARSAI, it's applicable in case of every, it's more actually lender specific. So if the lender happens to be a secured creditor as defined under SARFAESI Act, then the question of registration with SARSAI comes in. In case of motor vehicles, any lender whatsoever, no matter whether the lender happens to be a SARFAESI Act lender or not, every lender, in order to secure one's own interests, in order to ensure that the vehicle does have an endorsement on the registration certificate, every lender would like to have the endorsement on the registration certificate, the RC of the motor vehicle, so to say. In case of Companies Act charges, well, the obligation is primarily on the borrower. The borrower must register. The borrower happens to be a company. Sure enough, the Companies Act is applicable only if the borrower is a company. If the borrower is a company, the borrower happens to be a company, and the company has created a charge on any of its properties, the company is required, obligated under the law to register the charge. Failure of registration would render the charge as invalid. The charge becomes void against the creditor or liquidator. That's a specific provision of the Companies Act. It's always been that way. It's not the Volkswagen ruling which changes the law. The law has always been that way. But as I said, these rulings actually help as a sort of a reminder. So the obligation to register is on the financier under SARFAESI Act, on the user of the motor vehicle under the motor vehicles registration certificate, and is on the borrower once again in case of Companies Act. Intent of registration, of course, in case of SARFAESI Act, the intent is number one, perfection of security interests. SARFAESI Act has an elaborate, so to say, an elaborate thinking or a wide thinking of a perfection and utmost prioritization of security interest of a secured lender, which overrides the interest of any other competing lender. I mean, there's a ground thinking behind the SARFAESI Act that if a secured creditor gives or has a security interest in an asset, that should rank above the claims of every other claimant, including even a government. Even if a government comes with an attachment order and the property has a security interest which is already perfected, the interest of the secured lender ranks even above the claims of a government authority. That is the thinking under so-called sections 26B, C, D, E of the SARFAESI Act. So the idea of SARFAESI Act registration is to provide the lender with prioritization, utmost priority of the security interest over the asset. That's the intent of SARFAESI Act. The intent of the Motor Vehicles Act, of course, is operational completely. The vehicle applies with a registration certificate. The vehicle could be transferred by the borrower. So any transactions in the vehicle, including resale of the motor vehicle by the user of the owner of the motor vehicle, will have to be after the clearing of the the charge holder, the endorsee on the registration certificate, whose clearance will be required for any dealings with the any dealings in the motor vehicle. I'm sure one can understand, if the motor vehicle did not have such endorsement on the RC, I can actually resell my motor vehicle freely, take cash and walk out. So that's the intent. And that's, now let's also understand the impact of non-res, very important. Impact of non-registration. If I do not register, the registration is missing, what exactly is the impact? So in case of SARFAESI, the SARFAESI rights, the priority of security interest, which is coming by virtue of SARFAESI Act, Section 26D of SARFAESI Act particularly, the priority of security interests, the prioritization right, which is coming from SARFAESI Act, that will be lost. I'm not saying the rights of repossession, which come under Section 13 of SARFAESI Act. Several banks and NBFCs are empowered to take action of repossession under Section 13 by 2 and 13 by 4 of the SARFAESI Act. I'm not saying those rights will go away. If you have a clear hypothecation, you'll still probably have those rights. It's a contestable question though, but probably you'll still have the right. But the priority which is coming by way of Section 26D, that priority will be lost. Assuming for a minute that you are not registered, your security interest is not registered, and I come as a subsequent lender and I register my charge is registered, that will override an unregistered security interest in terms of SARFAESI Act. SARFAESI Act does not affect the validity. Important to mention, SARFAESI Act does not affect the validity of the security interest. What SARFAESI does is to affect the priority. Now, in case of Motor Vehicles Act, there is no impact as such. Just that the owner of the vehicle will be free to deal with the vehicle should the owner so like. So there is no impact as such. And under the Companies Act, the impact is even more serious. The charge becomes void. The charge becomes void as against a creditor or liquidator. Now, the serious question is the fact that the charge becomes void. Does that mean the charge is void from all respective points of view? For example, even under motor vehicles, even under common law, can I say that I don't have a security interest at all under common law as well? Companies Act does not as such say that the charge is vitiated for all purposes. Companies Act says the charge would be void against the creditor or against the liquidator. It refers in so many words, the charge would be void against the liquidator, which means at least in liquidation, at least in insolvency or liquidation, the charge holder will not rank at par with a secured creditor. The charge holder will become an unsecured creditor. And I'm sure it's easy to understand that unsecured creditors' priorities under IBC, under Insolvency Bankruptcy Code, are much lower than those of a secured creditor. Secured creditor ranks at number 2. Unsecured creditor ranks at number 4 or number 5 perhaps. So unsecured creditors' priorities will be much, much lower. And sure enough, as insolvency is a case of a shortfall on the value of assets, the secured creditors would grab it all, leaving nothing for the unsecured creditor. Now the question I was mentioning, that while registration of security interest has existed under the Companies Act for years altogether, and everyone knows that companies are required to register charges, but in case of motor vehicles, why is this question so very particularly, what was the need for us to bring up this question today in case of motor vehicles? The region where the question becomes important in case of motor vehicles is that in case of motor vehicles, I'm aware, and I would easily say that that is actually the prevailing practice. So for most cases where the borrowers happens to be companies, financiers do not, as a matter of post-disbursement check, financiers do not have adequate, so-called, let's say, adequate procedures to ensure registration of the charge by the borrowers with the registrar of companies. Left to themselves, while the obligation is on the companies, but issue is, are the companies taking sufficient steps to register charges on motor vehicles? Mostly the answer would be no, because companies are not very serious about that. Why are companies not serious? Companies are very serious when it comes to loans taken from banks. Let's say for machinery, or let's say a loan against real estate. They're very, very serious on registration, because the implications are the lenders step up their rate of interest. They start charging a penal rate. In case of motor vehicles, borrowers visualize the motor vehicle loan as a short-term loan. The tenure is hardly 2 to 3 years, 3 or 4 years. And even during the 3 to 4 years, the charge could actually be prepaid. The loan could be prepaid. The motor vehicle could be sold. So operationally, a motor vehicle loan for a company is a very small item in its overall scheme of funding. It's what? It's a 4 lakhs, 5 lakhs, 10 lakh kind of a loan. against a huge, financial edifice, and therefore, and of course, the charges taken by the operational team. I mean, the administration or the estate management team is the one which is probably charged with responsibility of acquiring vehicles. They would probably go to one of the banks and take a vehicle on loan. So they are not so sensitized on the need for registration. Short-term loan, mostly taken by the estate management team. Therefore, they are not properly sensitized. And they would kind of try to avoid the rigmarole of a registration of charge and be thereafter satisfaction of the charge once the loan gets fully repaid. It's a short-term 3 to 4 year phenomenon. So companies just don't bother. Companies do not bother. Financiers do not probably. Financiers need to bother, of course, but the fact is that they bother even less. And therefore, in most cases of motor vehicle financing to borrowers, the charges remain unregistered. Most companies probably, in their mind, they think that if they have the RC bears the endorsement, that's all that they need. They don't bother about Companies Act registration at all. Now the question is, if registration is not done, what's the implication? Does it affect my recovery right? Volkswagen case, the ruling I referred to, is a I don't think this is something that happens every now and then. Because the issue is, before a borrower slips into insolvency or slips into liquidation, you have every right to repossess the vehicle. You have a right to repossess the vehicle under your loan agreement. You have a right to repossess the vehicle under the SARFAESI Act. You have a right to repossess the vehicle under common law. So lenders do not have to wait for an enforcement under Section 52 of Insolvency Bankruptcy Code. I think that's least expected. Most companies would not even wait for repossession under Insolvency Bankruptcy Code. But the question is, sometimes insolvency might take you by surprise. If insolvency or liquidation filings have taken you by surprise, your funding has remained, you are still happily thinking that I have a charge on the motor vehicle and therefore I should be ranking at par with secured creditors. If the charge was not registered with the registrar of companies, you will actually be ranking at par with unsecured creditors. Now, quickly some point as to whether registration of charge would be required in these cases as well. In case of a financial lease, while one can see a dichotomy because SARFAESI Act itself defines a financial lease as a case of financial assistance. SARFAESI Act definition was amended in 2016 to define the word financial assistance to include a financial lease as well. Yet, for the purpose of Section 77 registration, which is coming under the Companies Act, in my view, a financial lease is not a charge. It's a case of ownership retained by the lessor. So question of registration does not arise in case of financial lease. More so in case of operating lease, I don't need to maybe stress further. Hire purchase, the traditional Indian instrument, which has existed over the years. Of course, with the imposition of value-added taxes across the country, hire purchases virtually become extinct. But that's how the entire finance industry was prevailing for 6 or 7 decades. In case of hire purchase as well, my contention would be that it's a case of retention of title. It's not a case of retention of security interest, retention of title, unless the matter happens to be that of so-called hire purchase financing. That's a hybrid transaction. I mean, spoken of years ago in a Supreme Court ruling called Sundaram Finance Limited, and subsequently a Madras High Court ruling in the case called Mansova and Company. Those cases apart, these are extremely, I would say, specific cases of mostly in case of second-hand vehicle financing. Otherwise, in hire purchase as well, in my view, registration of security interest will not be required. In case of a credit sale, of course, there's no question of charge because it's not a property of the borrower at all. And so also in case of co-borrowing, if the co-borrower happens to be a company, the question would basically be, is the co-borrowing a property of the co-borrower? If the co-borrower happens to be a company and the asset in question is jointly owned, the asset is also the joint property of the company, in that case, registration of security interest would still be required. So I was on the larger question, why do we need to stand up and pay heed to my discussion to my lecture today? Is this something a compliance issue? Surely not. Is it going to kind of affect recoveries of, I mean, non-banking finance companies or banks on the vehicles lent out to companies? I would once again say mostly not, because your common law rights are not affected your SARFAESI rights are not affected. That's what I would like to contend. I'm sure borrowers would try to take advantage of the Volkswagen ruling if you have not registered charges. But my perception would be that this ruling is limited to insolvency law, insolvency priorities. It does not affect your common law rights. Fact of non-registration, which is the obligation by the borrower itself, cannot put the financier to a disadvantage. The lapses on the part of the borrower was charged by the law with responsibility of registration, and non-registration by the borrower cannot prejudice the interest of the financier. That's my contention. Of course, there will be controversy on this as well. So issue basically is that it's not going to affect your recovery rights in commonplace, but at the same time, I would strongly recommend that financiers need to stand up, take notice of this ruling. That was the law always, but sort of reminded about this position of law, and therefore stand up and take notice and do ensure that wherever you have a loan given to a corporate company or an LLP, in case of LLPs, it's optional. In case of loans given to companies, mandatory. In case of LLPs, it's optional. If you have a loan given to a company, then please do ensure that the company has registered the charge. Otherwise, your priority under insolvency law would be missing. Now, the next question is, if you were to, well, you would have done such cases of vehicle financing over the years, and you would, I wouldn't be surprised, but I'm guessing you will probably have this unpleasant surprise if you go and start checking in how many cases your vehicles given on loan to companies charges were not registered. You'd probably come with unpleasant surprise that in most cases registrations have been missing, because most companies don't have a strict post disbursement check on that. So if the charge has not been registered, is it too late? In terms of law, probably yes, because the Companies Act has definitive timelines, 30 days, and then extension of 60 days, another extension of 60 days. So all you have basically is a total of 120 days, 150 days for registration. If you already passed 150 days, 5 months are gone, then there is no way you can register. So either you can continue to relax and think, well, the vehicle will probably be paid off. You may not do anything at all. But if you actually want to perfect your security interest, I would suggest you can actually have a supplementary agreement as of now, refreshing the security interest you had created 5 months back, and register that supplementary agreement along with the original loan agreement as an annex. This is a kind of actionable I would suggest for all companies. This was a short presentation on a problem which is, I would say, it's not something which was unknown, or not something that, well, at least in my course of teachings all over the years, I've consistently said the same thing, that you need to ensure registration of security interest. But nevertheless, good that at least we became reminded of this issue by the NCLAT ruling. Well, with this, thank you very much for watching this video, and wish you all the very best.